Okay, we have to test our mics out. So everybody said I was too low the other day. I don't know if I'm live on here or just Gavel Chasers. I cannot tell. Cannot tell. Let me see something. Okay, here we go. Let me listen. That's low. All right. That's the Yeti. Ugh. All right, let me try the camera. How's the sound on this? I'm listening to myself. Ugh. Absolutely not. All right. Let's see the sound on this one. I have so many mics. All right, I think this one's fine. Yeah? All right, I won't touch it. Yeah, this one sounds okay, I guess. The first was way louder? Suspicious. I have it close to my face, too. Here we go. Good. All right. We left off on page 52, and I know a lot of people are live, so it's just going to be a little, it's just us, okay? We left off on page 52, and they were going back in time and telling all the stuff. So, on February 19th, 2017, law enforcement interviewed Westfall. Westfall's Patrick Westfall. That was a big sigh, sorry. They also failed to record that interview. Only a 5-paragraph narrative remains. According to his narrative, Westfall knew the woods where the girls were murdered very well. He reported knowing the girls, but denied ever meeting them. He also reported being a religious leader for local pagans, and he wore a necklace to the interview representing his efforts to pledge to the Vinlanders, which is a pagan social club. There is no indication that law enforcement asked Westfall whether he owned a .40 caliber firearm, and his phone was not searched. C. When asked for an alibi, Westfall claimed he was home with his minor son, and Holder told the police officers he was at work at Liberty Landfill. On April 13, 2017, 4 officers visited the landfill to investigate and spoke with an employee named Susan Case, who provided a printout showing that Holder swiped out of work at 2:45 p.m., which was 30 minutes after the bridge guy video. Case invited the officers to review the video to confirm the printout's accuracy, but they declined, nor did they interview other people. Unified Command marked Holder as cleared as a suspect. Tipsters continued to identify Holder as the bridge guy. Tipsters repeatedly called and reported Holder as a person of interest. Holder posts half-dead women and shows fascinations with symbols made out of tree branches. Check the father of one of the girls' boyfriend. His name is Brad Holder. He also somewhat fits the description. Each time a tip came in, law enforcement marked it clear, nothing further, covered, or alibi confirmed. Now, so if you've got people calling in tips all the time, saying, check one of the girl's boyfriend's dad. He looks like the guy. He has a fascination with all of this stuff, with these symbols, these branches. He posts half-dead women, and they just keep marking it cleared. Sometime around March 17th, Detective Purdy interviewed Holder to get his assistance in connecting the murders to Norse paganism. Because Holder was not a suspect, Purdy did not record or document this interview with a report. Does anybody else find it very strange that Holder's interviews were not documented or recorded, and Westfall's interview wasn't either? I mean, they really screwed this up from the beginning to the end. Unified Command declines to re-interview, despite reports Holder is posting pictures of young girls believed to be deceased with sticks placed over their bodies. On April 12, 2017, shortly before taking medical leave, Trooper Winters receives a call from a tipster, Ryan Boucher. He shared pictures from Holder's social media. Winters found a concerning similarity between the murders and the pictures posted on Holder's social media. Those pictures depicted young girls believed to be deceased with sticks placed over their bodies. Winters also noted similarity between the stick formation on Abby and a bind rune Holder tattooed or drew on his hand, and I showed you guys that the last time. That is a bind rune on my hand. Basically, I took a Jeppo rune and an Isa rune and made a bind rune. Holder's social media also features him holding guns and a homemade knives. Winter immediately recommended to his superiors that law enforcement investigate Holder further, which they declined to do, claiming his alibi was cleared by the FBI. Winters was not satisfied and urged the ISP to conduct its own investigation. No further action was taken. In 2018, Holder displayed a painting he made of Odin upside down with his right leg tucked behind his left, just like Abby's legs. Holder also featured a red F Feu rune, which is the one that people think they see on the tree. Officers continue to find other social media postings from Holder that mimicked the crime scene, but law enforcement declined to interview him again. Pagans finally reevaluated. Once the state charged Allen, his defense team insisted that Holder and Westfall receive another look. When law enforcement re-examined Holder, he changed his story about knowing Abby. Back in 2017, he told law enforcement he had actually never met Abby. But in August of 2023, he told law enforcement he met Abby once. And during a deposition in 2024, he said he met Abby twice. At least one of those encounters occurred shortly before Abby's murder At least one of those encounters occurred shortly before Abby's murder, and it was at the Westfall home. So at Patrick Westfall's house, Abby was there shortly before she was killed. Does anybody just think that that's bonkers to me. I mean, yeah, the cement will wait. Isn't that strange? That, I mean, maybe he just didn't want to implicate himself, either of them. So they're like, no, I never met them. But, I mean, if you've met them, just say that you have. And for Westfall to say he doesn't know her at all, but one of the times that Holder met her was in Westfall's home. They would have had to have brought her to Westfall's home for that to happen, because why would Westfall have any access or any knowledge of who Abby is when Abby's dating Holder's son? Holder is Westfall's friend. So, okay. I don't like it. At the insistence of Allen's counsel, law enforcement finally examined Westfall's alibi on August 17th, 2023. Westfall's son, who was a minor when the murders occurred, could not remember if he was home with his dad when those girls went missing. This time, law enforcement collected Westfall's phone, but he had deleted the data before he turned it over. Why? On April 4th, 2024, Allen's counsel deposed Case, the Liberty Landfill HR officer. In February of 2017, Liberty Landfill was operating two staggered overlapping shifts, one from 5 a.m. to 1:30 and a second from 7 a.m. to 3:30. On the day the girls went missing, Holder was scheduled to work from 5 a.m. to 1:30, but his badge swiped out during second shift around 2:45 p.m. Holder did not have sole custody of his badge. His badge was on a public rack outside of the view of the camera, accessible to other employees, including second shift. There was no lock on the badges, and Holder's name was prominent on his badge. If somebody left when they were supposed to, but somebody else clocked that person out an hour or so later, would that be known? Answer, no. When the state moved to exclude any reference to the state's investigation into third parties, the trial court held a hearing on the motion in July of 2024, which I totally thought is bullshit, because if your defense is you believe there's third-party culprits, for the judge to deny that, I mean, that's pretty devastating. So, at that hearing, Holder's wife testified that in 2018, Holder told her he had a fight with Westfall because Westfall wanted to up from animal slaughter to a different type of sacrifice. She also testified that Holder claimed that Westfall killed Abby with others and that she needed to keep her mouth shut. Think about that. So she testifies and says they're arguing, or they had an argument, because he wanted to up from animal slaughter to a different type. Well, what's after animals? What's after the animals? Clearly people. Now this is the summary of the argument. The trial court committed reversible error by admitting evidence seized under unconstitutional warrant and by denying Allen a Franks hearing. Detective Liggett obtained a warrant for Allen's home only by omitting and altering witness descriptions to connect Allen to the bridge guy, and by misrepresenting that Allen admitted that he wore the blue Carhartt jacket like the bridge guy. These misrepresentations and omissions misled the judge into believing multiple witnesses saw Allen and his car when in fact they described someone else and a different car. Once the affidavit is corrected, there is no probable cause. Unprecedented confinement. Allen's confessions were involuntary and the product of grave mental disability caused by 13 months of maximum security pre-trial solitary confinement, which exceeded the IDOC policy, caused psychosis, paranoia, and confusion, while state actors were indifferent to his deterioration. Admission of these statements violated both federal due process and Indiana's protections against unnecessary rigor, and the error was not harmless, requiring suppression. Unfair trial. The trial court denied Allen his constitutional right to a fair trial through a series of arbitrary and prejudicial rulings that crippled his ability to present a complete defense. The trial court excluded critical exculpatory evidence, including Blair's sketch, which directly undermined the state witness's theory and timeline, and barred expert testimony challenging the reliability of the state's forensic methodology. It permitted inadmissible hearsay to rehabilitate the prosecution's timeline, and it blocked Allen from presenting evidence that showed the circumstances that led to his confessions and impeached their credibility, including audio depicting his deteriorated mental state. The court further prevented Allen from introducing substantial evidence of third-party guilt and incomplete investigation, depriving the jury of context necessary to assess reasonable doubt. Collectively, these errors violated Allen's 14th and 6th Amendment rights and created a fundamentally one-sided proceeding. A new trial is constitutionally required to restore the integrity of the adversarial process. So now their argument. 1. The trial court committed reversible error by admitting evidence seized from the unconstitutional search of Allen's home and denying a Frank's hearing. When reviewing the admissions of evidence after a denial of a motion to suppress, the court considers evidence favorable to the ruling and uncontradicted evidence to the contrary. Factual findings are reviewed for clear error, but the constitutionality of a search is reviewed de novo. I don't know what that means. Is reviewed de novo. What is this de novo? From the beginning. Okay. So, factual findings are reviewed for clear error, but the constitutionality of a search is reviewed from the beginning. Okay. Allen filed a motion to suppress, a motion for a Frank's hearing, amended requests, and a lengthy memorandum with exhibits. The trial court denied the motion and the hearing, concluding Liggett's affidavit did not include false statements or omit facts with reckless disregard or intent to mislead. Sure it didn't. Okay. The trial court erred by concluding Detective Liggett did not make false statements or reckless omissions in his affidavit. Both the state and the U.S. Constitution guarantee that no warrants shall issue but upon probable cause supported by oath or affirmations. U.S. Constitution. The state must include all material facts in a warrant application, including facts that cast doubt on the existence of probable cause and a source's reliability. A warrant is invalid if the police omit facts with the intent to make the affidavit misleading or with reckless disregard for whether it would be misleading. 2. The affidavit supplemented with the omitted information would have been insufficient to support a finding of probable cause. The defendant must prove a reckless or deliberate false statement by a preponderance. An officer omits evidence with reckless disregard if the officer withholds a fact that his ken. An officer omits evidence with reckless disregard if the officer withholds a fact that is in his ken that any reasonable person would have known that the judge would wish to know. Examples include facts undermining the type of drug seized or an informant's reliability. This includes details undermining an officer's conclusion. For an example, Jaggers versus State, marijuana field office described as near defendant's house, but was 2 to 6 miles away. Detective misleads court by incorrectly reporting a witness's description of a suspect, equating description with defendant. Okay. Detective Liggett omitted and changed key information that undermined his conclusion that Allen was the bridge guy. Liggett misled the court in 4 ways. First, he misled them to believe Blair's description of the man on the bridge matched Allen when it did not. Liggett told the court that Blair said the man was standing on the platform wearing a blue jacket and jeans, but Liggett omitted the rest of her description that did not match Allen. The man had poofy brown hair, like the sketch below, was in his 20s or 30s, youthful and medium built. So I have to ask, how the hell is that even legal? She gives you this whole description of this person that she's sure is the person she was looking at. And you just completely mislead the court and give them this crazy description because you want it to match the person that you're talking about. How is that not like a prosecutable offense for an officer? I can't really get past that. Wouldn't you think that they should be in trouble for that? In my opinion, I would say that they should, right? Like, what kind of people do this? Second, Liggett misled the court that Allen's car was parked at the old CPS lot during the time of the kidnappings. Detective Liggett told the court that after Blair saw the man on the bridge, she saw 2 girls that she thought were Abby and Libby on the trail approaching the bridge. As Blair was leaving the trail, she saw a car oddly parked at the old CPS lot. Around 2:10 p.m., another witness, Wilson, also saw a car parked in the CPS lot, and it was backed in as if someone was concealing the license plate. Both witnesses drew diagrams of the car parked in the same general area and manner. Liggett told the court that Allen parked his black 2016 Ford Focus at the old CPS building, but omitted that Blair said the car she saw during that time was not black and had sharp angles like the sketch below. Here we go with that weird sketch that she drew. Considering the omitted information, Blair excluded Allen's black hatchback. What the hell? This round car and then this weird meme. That isn't, it's not even a car. What in the hell is that? And this is something that you guys kept in evidence? That thing? What even is that? That's not a car. It's a line. So extremely strange that they used that. This is a material omission. Invalid warrant where officer changed witness's car description in a drive-by shooting, as an example in U.S. versus Wells. Third, Liggett misled the court that the man walking on 300 North was Bridge Guy. Liggett falsely told the court that Sarah Carbar in 2017 claimed the man was muddy and bloody and wearing a blue jacket when she actually said his jacket was tan and he was muddy. A bloody man in a blue jacket matches Bridge Guy. A muddy man in a tan jacket, does not. Liggett also omitted that Blair told him the man she saw on the bridge was not the same person that Sarah saw. ISP even released a public statement that the men are not the same person. Fourth, Liggett connected Allen to Bridge Guy by falsely claiming Allen admitted wearing a black or blue Carhartt jacket and a head covering. Now, the man the 4 girls saw wore the same clothing as the man on LG's phone, on Libby's phone. The clothes Allen admitted he wore matched the clothes by the individual on the bridge in the photo taken from the video on LG's phone. But Allen told investigators he didn't know what he was wearing. Although Liggett used Allen's wife's statement that Allen currently owned a blue Carhartt as a nexus to his home, Liggett omitted that she said he purchased this coat a couple of years ago. The girls were killed in 2017, so that wouldn't have been a couple of years ago. Had the court known Allen simply admitted owning a blue or black coat, as probably does every 50-year-old man, they would have known there's no connection there between him and the bridge guy and the clothing. Detective Liggett's omissions and false statements recklessly misled the judge. Any reasonable person would have known the judge would wish to know that 1. Blair's description of bridge guy and the car at CPS did not match Allen or his car. 2. That in 2017, Sarah described the man walking down the road as only muddy and wearing a tan jacket, not a blue jacket like the bridge guy. 3. Blair did not believe she saw the same man that Sarah saw. 4. Allen never said he wore the blue Carhartt or a head covering like bridge guy, and he bought his blue Carhartt a couple of years before 2022. The omitted and false information strikes at the heart of Liggett's conclusion that Allen was the man on Libby's phone. The state's probable cause relies on a tight timeline, making Allen the man the 4 girls saw on the trail, Blair saw on the bridge, and Sarah saw on the road. Any judge would want to know if witnesses described someone other than Allen, his car, or the bridge guy. Moreover, the fact that Liggett lied twice in the affidavit about the connection between Allen and bridge guy shows more than reckless disregard for truth. These falsehoods were directed at connecting Allen to Libby's video, which would otherwise include any white man. 3. With the omitted and accurate evidence, the affidavit was insufficient to establish probable cause. Probable cause exists when there is sufficient evidence to cause a reasonably prudent person to believe such a search will uncover evidence of a crime. A reasonably prudent person would not believe Allen was connected to the murders or that the evidence would be found in his home. The state is left with Dullen's report, claiming that Allen told him he was on the trails between 1:30 and 3:30 and saw 3 girls, not 4, like those who thought they saw a bridge guy. During his October 13th, 2022 interview, Allen admitted wearing blue jeans and owning a gun, knives, and a blue or black jacket, and walking out to the first platform of the bridge to watch the fish. But Allen doesn't look anything like the person Blair saw on the bridge. Also, his car is a different color and shape than the oddly parked car, and the man Sarah saw walking was most likely not even bridge guy. If Allen being on the trail within the same 2 hours the girls were abducted is enough for a warrant, law enforcement would have obtained one for Allen's home in 2017. In 2022, ISP had no more evidence connecting Allen to the murders than they had days after the murders, when Allen, like others, responded to their request for help. If it was not enough then, it was not enough in 2022. Good point. The error requires reversal. A court must suppress fruits of an illegal search. The state's entire case is built on Liggett's half-truths and falsehoods. Without the gun seized in the search, there is no opinion from Oberg upon which the state arrested Allen. And without the arrest, there are no confessions. If the warrant was illegal, the state has no case. Even if this court finds the confession was not a product of solitary, then Allen is still entitled to a new trial. Before a constitutional error can be held harmless, the court must find it was harmless beyond a reasonable doubt. Chapman versus California. Without the fruits of the search, the gun, a casing in a Hope box, the Carhartt, knives, and computer, the state cannot prove the jury would have convicted him. At minimum, Allen is entitled to a remand for Frank's hearing. I would say at minimum. Even if Allen's exhibits to the Franks motion did not prove by a preponderance that Liggett deliberately or recklessly falsified or omitted material information, they entitled him to a hearing. A defendant who makes a substantial preliminary showing that an affidavit included in a false statement or reckless omission necessary to probable cause is constitutionally entitled to challenge the warrant at a hearing. I mean, it's like they saw all this, they've heard not all of this, but all of the stuff all together, and they were just like, no. This case has gone on too long, and it sounds like he could have done it, so he did it. Let's just leave it there and move along. It's very frustrating. To meet this showing, the defendant need not present conclusive proof, but must support their accusations with evidence and citations to warrant the application. Here, the court's denial of a hearing was legally erroneous because Allen had made a substantial showing. Allen supported his claims with depositions, police interviews, and reports. Citing Liggett's application, Allen made specific arguments. In a final motion, Allen reiterated these points, urging the court to compare the affidavit with Blair's and Sarah's interviews. Tellingly, the trial court was willing to schedule a Franks hearing when Allen was represented by Fort Wayne attorneys, but refused when the original attorneys were reinstated. That's so crazy. Allen's constitutional protections are not contingent upon who his attorneys are. The trial court erred by admitting statements Allen made while gravely disabled during his unprecedented pretrial solitary confinement in a maximum security prison. So crazy to me that they put him in a max security in solitary like it was nothing and nobody cared. A Nelson Mandela quote: "I found solitary confinement the most forbidding aspect of prison life. There is no end and no beginning. There is only one's mind, which can begin to play tricks. Was that a dream, or did it really happen? One begins to question everything." I can't imagine being locked up like that until whenever, until whenever they say you're going to get out or not get out or whatever it might be. That, to me, that just sounds horrible. Just close, go close your door and lock it and know you got to poop in there, you got to pee in there. You're like your bathroom door, right? And the bathtub's your bed, but you can't turn the bathroom on, the shower on or nothing. You just got to lay there in the dark and hope somebody's going to give a shit to come in there. I mean, it's baffling to me that they were allowed to do this to this man. It really is. Solitary confinement is a form of punishment, and depending on its conditions, even torture. By 2023, when Allen was held in solitary for 13 months, it was well established that prolonged isolation causes psychological pain, suicidal ideation, and psychosis. To protect inmates from psychological harm, the IDOC strictly prohibits solitary confinement over 30 days for anyone with serious mental illness, and requires transfer if serious mental illness symptoms appear. 1 second, I'm sorry. These dogs are wackos. They're fighting over a bone that neither one of them actually wants. When Allen exhibited the predictable symptoms of psychological pain, confusion, and psychosis, the IDOC administrators refused to transfer him to a mental health unit. Why, though? When Allen's attorneys informed the court of his dire condition, the court also refused to move him, and the prosecutors delayed and mocked counsel's concerns while collecting evidence of Allen's confessions. That is psychotic. The question for this court is unprecedented but simple. Should the state be able to benefit from Allen's psychological pain that their deliberate indifference to his mental health caused? Human decency provides the answer: no. An appellate court reviews a suppression denial for substantial evidence of probative value that supports the trial court's decision. This is from another case. It considers uncontradicted evidence favorable to the defendant and reviews legal issues from the beginning, now that we know what de novo means. The voluntariness of a confession is a legal issue. Allen moved to suppress his statements made while in solitary confinement, which the court denied. Shocking. The court reasoned that the statements were voluntary because Allen failed to show that they resulted from state psychological coercion or interrogation. But weren't they? Okay. So no, nobody was physically there forcing him to say these things. No, but he was rambling and putting himself, eating his own feces. What the hell do you think it was? The court found Allen's detention was intended to protect him, and that while he suffered from major depressive disorder and anxiety, he did not have SMI that would render his statements involuntary. I mean, he was sticking his penis with a spork. He was drinking from the toilet. It's actually, I don't understand who these people are and why they would go to the lengths for this. To solve the case and to put it behind them, maybe? I guess. In addition to the IDOC records and videos like those admitted at trial, Allen proffered... Stop right now, Lola. Lola, I'm going to take your bone. Come here. Not you, Brady. Lola, stop being a mean psychopath. She's the worst dog ever. Okay. In addition to the IDOC records and videos like those admitted at trial, Allen proffered an order and settlement from the Indiana Protection and Advocacy, the IPAS, that the trial court excluded from the suppression hearing as irrelevant. 1 second. Lola, come here, please. You are far out of control, ma'am. Lemon. Come lay down, please. Please. Y'all like Britney's children. Right? You just gotta act. You just gotta talk and act up and do all the things. Please. Do you understand? Come on. Enough. Shh. Lay down. Do you understand? Lay down. That doesn't mean sit right under me and breathe like a French bulldog, which is so loud. Okay. All right. In 2011, the Southern District of Indiana held that the IDOC's housing of SMI inmates in solitary constituted cruel and unusual punishment, violating the Eighth Amendment. The Southern District found SMI includes delusional disorder, psychotic disorder, and MDD. Segregation is harmful to prisoners with SMI due to lack of social interaction, significant sensory deprivation, and forced idleness, leading to decompensation and psychological pain. An inmate decompensating from solitary may experience hallucinations, sleep disturbances, memory problems, anxiety, paranoia, depression, eating problems, and engaging in self-injury or suicide. No. Okay. Okay there. Really? You're a lot, little mama. The severe conditions in the segregation units cause a predictable deterioration of SMI prisoners' mental health, and the IDOC has explicitly observed and diagnosed and noticed patient decompensation. The IDOC knew these effects occurred even in non-SMI offenders. Before hearing on relief, the parties reached a settlement including an expanded definition of SMI that subsumed the court's definition. The IDOC's policies refer to the settlement, which sets the policy tone. Listen, snort face. Come on. An inmate with SMI can only be held in solitary for 30 days. If an inmate decompensates into SMI and is unlikely to return to general pop within 30 days, transfer is required. Allen admitted Dr. Westcott's 127-page report. On August 21st, 2023, Westcott evaluated Allen, who had been in WCU over 9 months. He was terrified, unsure what was real, and wondering if he was dead, in hell, or waiting for heaven. He could not recall weeks of early 2023, including playing with feces, confessing, or banging his head. He believed he had been drugged. Westcott cited IDOC records showing acute periods of confusion, paranoia, delusional thinking, cognitive slowing, aggression, and combativeness. During this period of loss of touch with reality, Allen confessed. Westcott concluded Allen's psychosis stemmed from MDD, his personality, and the well-known effects of solitary confinement. Allen was grossly disorganized, delusional, and paranoid. Objective testing ruled out malingering. The trial court abused its discretion by refusing to admit the IPAS order settlement into the suppression hearing. Evidence is relevant if it has any tendency to make a fact of consequences in determining the action, more or less probable than it would have been without it. Here, the order settlement makes it more likely Allen's psychosis was caused by his confinement. The order found solitary confinement causes all the symptoms that Allen experienced. Allen was more likely to decompensate because he spent 7 months on suicide watch, and even more restrictive form of solitary. The order settlement also makes it more likely Allen was subjected to psychological coercion by showing solitary causes psychological pain. It demonstrates state action, the IDOC, placing and keeping Allen in solitary, knowing this was predictable pain. The order settlement shows how extensively IDOC violated its own policy, as it includes MDD in the serious mental illness definition. What, ma'am? Restricting Allen's solitary to 30 days. All right, are you ready to get down? Oh boy, she's waiting for you. She's about to jack you up, sister. All right, go ahead. Go ahead. Go. Now that everybody's calm and you got a puppy massage, go. Yeah, I do need a baby carrier. It's insane. But the bullet and other evidence. Yeah, the bullet's not evidence. I don't believe the bullet's evidence at all. Not at all. All right. The order settlement shows how extensively IDOC violated its own policy, as it includes MDD in the SMI definition, restricting Allen's solitary to 30 days. Allen was harmed by the court's refusal to consider the order settlement because it undermined the court's findings and conclusions. The state failed to prove Allen's statements, while gravely disabled, were voluntary. U.S. Constitution. The state failed to prove that Allen's statements were not a product of psychological coercion. An involuntary statement obtained through state action violates due process and is inadmissible. A confession is voluntary if it is a product of rational intellect and freely self-determined, rather than overborne by state law enforcement conduct. So how are they going to say that well, I guess by locking him up. You know, nobody was forcing him to say those things, but he became crazy because he was locked in there. State law enforcement can include psychiatric facilities and prison staff. Statements produced through a coercive environment are involuntary, regardless of whether solicited through police interrogation. Okay, so they reference United States versus Karaki, and they say months spent in solitary confinement, deprived of light, adequate food, and contact with the outside world is by itself sufficient to sustain a finding of involuntariness. So that's already been proven through United States versus Karaki. Okay. They go on to cite 7th Circuit, 1997. Staff at a state psychiatric facility created a coercive environment, rendering a juvenile's confession involuntary. The crucial element is police overreaching. When state actors use more subtle forms of psychological coercion, the defendant's mental illness is more significant in the voluntariness determination. Spano versus New York. But the state must still exploit the defendant's illness with coercive tactics. So they're doing a lot of referencing here. This is generally done through aggressive interrogation, but exploitation can occur in other ways. It is difficult to imagine a situation in which a confession would be less the product of free intellect, less voluntary, than when brought about by a drug having the effect of truth serum. So are they talking about when they were giving him the Haldol? For a statement to be involuntary, state action must be causally related to the confession. The state's prolonged solitary confinement of Allen was state action. Contrary to the court's finding that Allen failed to prove state psychological coercion, it was the state's burden to prove Allen's statements voluntary by a preponderance of evidence. To the extent Allen had a minimal burden of production, he met that. Prolonged maximum security solitary confinement of a pre-trial detainee, especially after psychosis develops, is state action. Unlike the mental ill defendant in Conley, who walked into a police station and confessed, Allen never voluntarily came into custody. He consistently protested innocence until enduring 5 months of maximum security. Okay, so that's interesting. I guess I didn't put together the timeline on that. So he consistently said that he was innocent until the 5th month of this maximum security solitary confinement, with no human contact except when chained or caged. See, I thought it was sooner than that, but maybe it wasn't. Because it was pre-trial, Allen's solitary was unprecedented and borderline, if not unconstitutional punishment. Other IDOC safekeepers were in mental health units, not solitary. How is that possible? How is it possible? So they had other safekeepers, which is what they were calling him, but they were in mental health units and they put him in solitary. Why? I can't wait. Is there like an answer to all of this that we don't know about yet? I would love to know. On a continuum of possible punishments in the justice system, solitary confinement in a maximum security facility is the most extreme. Also, Allen's solitary exceeded the 30-day IDOC policy restriction. They knew it could harm him. When IDOC observed Allen's predictable deterioration, they refused to transfer him, keeping him in solitary when he was no doubt SMI was an administrative, not clinical decision. Finally, the state's conduct also involved the prosecutor, law enforcement, and the court. After Allen filed his April 5th emergency transfer motion citing his dire condition, the prosecutor waited 9 days to respond while investigators monitored real-time calls in which Allen confessed. During this delay, Allen continued to deteriorate. The prosecutor then mocked defense concerns as colorful and dramatic, while that same day IDOC found Allen gravely disabled. Oh, these people make me mad. Knowing Allen was decompensating, the court refused to transfer him, putting the onus on IDOC to provide care. It is fundamentally wrong to keep a gravely disabled Allen in solitary while using statements that he's making against him or using statements made to psychologists and suicide companions. 1 week later, the prosecutor sought all medical records, videos, and communications while confessions were ongoing. So it's like they have him in this jacked up situation, and then the prosecutor's like, yeah, I want all his medical records, all his videos, all of his communications. They were monitoring and collecting his statements, consumed hundreds of hours, and produced over 60 confessions. ISP interviewed inmates and guards and even sent a psychologist to speak with Dr. Walla. Allen showed more than sufficient state action. The state's prolonged pretrial solitary confinement was psychological coercion. Because it was prolonged, it caused psychological pain and put him at the mercy of the state. The prolonged nature is coercion because solitary confinement can bring a person to the edge of madness and perhaps to madness itself. This has been recognized in literature, law, and science. They cited Dickens' A Tale of Two Cities. That's pretty interesting. Solitary causes psychological trauma, including psychosis, hallucinations, and paranoia. They all knew this. From day one at WCU, Allen was placed in a strip cell, the most restrictive cell in the most restrictive solitary unit, with only the bare essentials and a camera constantly recording him. Soon thereafter, IDOC ordered guards to videotape him when out of the cell, including showering and with attorney visits. Suicide companions remained outside his door documenting everything, regardless of suicide watch status. He had no contact with anyone unless caged or chained. That is psycho. The sensory deprivation, social isolation, and forced idleness is difficult even for healthy people. I would assume so. So they talk about memory distrust syndrome, confabulation, and false confessions. A healthy man wrongfully implicated and detained in solitary, questioned his memory and suspected he committed the crime, though he stayed sane by reading, exercising, and praying. The experience traumatized him. Early videos show Alan pacing his 8.5 by 12.5 cell, laying down, doing leg crunches, writing, reading, and looking distressed. Cell videos, December to March. Within 2 weeks, Alan said he was broken and told his wife, "If this becomes too much for you, call the detectives and I will tell them whatever they want to know." Had Alan's solitary been 30 or even 90 days, he would not have decompensated, but it was 13 months. The prolonged solitary caused Alan predictable psychological pain, paranoia, nightmares, memory problems, and confusion. It is undisputed Alan deteriorated to being gravely disabled and very psychotic, and the IDOC involuntarily administered antipsychotics between April and late June. Although Dr. Wallen noted concerns about feigning, she diagnosed psychosis and suspected incompetence and overmedication. And WCU only monitored Alan's mental health. Talking with psychologists while shackled in a cage is not treatment. Solitary put Alan in a constant state of vulnerability. Solitary confinement has long been recognized as psychologically coercive, equated to the rack, the thumbscrew, and protracted questioning. Ugh. Pre-trial solitary is punishment, already underway, and conveys, without the necessity of spoken words, the implied threat of further punishment. I would agree with that. It does not matter why a defendant was in solitary, whether justified or whether the prison planned further punishment. In this harsh environment, Dr. Walla controlled all aspects of Alan's life, including whether he got bedding, clothes, meal items, books, personal items, and utensils. She could provide a new window and a tablet, or strip him to bare necessities. Privileges were contingent on pleasing her. Whether Walla had ill intent is irrelevant. It is what Alan thought and what solitary confinement did to him or would do to many of us. After confessing to Walla on May 3rd, he asked for his property back, and she indicated she needed more consistency. Senator McCain, a prison camp survivor, explains solitary crushes your spirit, weakens your resistance more effectively than any other form of mistreatment. Atul Gawande hellhole, The New Yorker. Alan entered solitary confinement compromised. He left broken. IDOC records show that Alan continued to suffer from psychotic during the times he confessed. On April 5th, when he confessed to Dr. Walla, he was not eating or sleeping and was drinking from a toilet. On May 3rd, when he confessed, Alan had symptoms of paranoia and disorientation. Despite Walla claiming he presented as more organized than he has been, the day before he was confusing nightmares with reality, claiming to have started World War III. 2 days before, he was too disjointed to even hold a conversation. Days earlier, he covered himself in feces and claimed he was King Michael. His confessions to guards occurred during bizarre and psychotic behavior. Guards believed he was faking, but they are not clinicians, and Dr. Westcott found no malingering through objective testing. Alan confessed to his family on April 3rd, May 10th, the 17th, the 25th, and June 11th. On April 3rd, he also fell on the floor, asked if he was dead, and was suicidal. On May 10th, he believed he was dead, that the world would blow up if he went to sleep, that his water was poisoned, and he was reliving the same day. On May 17th, he was paranoid of his attorneys and staff who had on Odin patches. On May 25th, Alan paced for 2 hours and was banging his head. On June 11th, he thought he was in hell and didn't understand what was happening. In August, Allen did not remember confessing or any of the weeks in early April. Throughout, he complained of memory loss. State action overbore Allen's will. Allen did not confess until after 5 to 7 months of solitary. Before arrest, he consistently denied involvement. Dr. Westcott opined Allen's psychosis was caused by the stress of solitary confinement on pre-existing illness. Dr. Walla agreed that a lot of time solitary confinement exacerbates mental illness, and it is reasonable to believe Allen's confinement caused his psychosis. Yeah, I think that would be reasonable. The social isolation of solitary makes people question themselves. If you are treated like you are guilty, you begin to think you are. Dr. Gracian testified a false memory starts with a belief. In his first confession to his wife, Allen said, "I think I did it." In his first confession to Dr. Walla, he was unsure if he had sex with the girls. Allen got facts wrong, confessed to crimes he did not commit. Allen claimed he shot the girls. Indiana Constitution. The state failed to prove Allen's statements were a product of rational intellect rather than the state's misconduct. The Indiana Constitution also protects against the admission of involuntary statements. Indiana's test is like the due process standard, requiring a confession to be freely self-determined by a rational intellect and free will. However, it is more robust because it requires the state to prove voluntariness beyond a reasonable doubt. So that's very interesting. Also, it does not require state action to be coercive to overcome a mentally ill person's will. Mentally ill defendant statements involuntary due to his altered state and confusion, although officers neither coerced him nor knew of his illness. But mental illness alone will not render a statement involuntary. There must be some negligence that contributed to overcoming the defendant's rational intellect. Here, the IDOC's refusal to apply their 30-day policy to Allen and to transfer him after he deteriorated is at a minimum negligent state conduct that caused his psychosis and confessions. And the prosecutor's delay and the trial court's refusal to set a timely hearing exacerbated the deterioration. This is conduct that our Constitution cannot tolerate, regardless of whether it constitutes coercion under federal due process. Also, the evidence does not show the statements were a product of rational intellect beyond a reasonable doubt. Allen was considered gravely disabled through June 16th when he received his last emergency injection due to self-harm. Though Wallace sometimes described Allen as more coherent or his symptoms not significant, the state cannot have it both ways. Allen decompensated to the point of forced medication but remained rational beyond a reasonable doubt. Even if Allen could occasionally hold the conversation, it does not render his confession voluntary. His prolonged solitary confinement violates Article 1, 12, and 15. Indiana courts are constitutionally bound by the basic concepts of fairness that are frequently identified with due process in the federal Constitution. Article 112 guarantees for every person for every injury done to him in his person, remedy by due course of law. Here, Allen was sent to solitary for safekeeping without even a hearing or notice. Even when his attorneys informed the court of his dire condition, the court refused to set a hearing in violation. Although the court eventually held a hearing on June 15th, 2023, by then the damage was done. Fairness protections in criminal cases are found in different Indiana constitutional provisions. McIntosh versus Melrose. Just as a pretrial punishment violates federal due process, it violates the Indiana Constitution. Indiana is just one of 6 states protecting citizens from unnecessary rigor. The framers wrote, "No person arrested or confined in jail shall be treated with unnecessary rigor." Typically, this provision requires a prisoner suffers severe mistreatment. Recognizing this provision applies to solitary confinement, the Indiana Supreme Court stated, "The very essence of punishment and the sole use of the prison walls is the confinement of the convict within them. Humanity indeed forbids, as unnecessary rigor, that his confinement should be absolutely solitary, or that all his natural and civil rights should be temporarily annihilated." Here, Allen's treatment rose to the level of unnecessary rigor. Rigor is the act or instance of strictness, severity, or cruelty. When Allen started suffering from confusion, memory lapse, paranoia, and bizarre behaviors, there was no longer a risk he could not handle the harsh conditions of maximum security solitary. It was a reality. The strictness, severity, and cruelty of his confinement is evident on video, where he is screaming in fear, confused about where he is, unable to respond, and drooling and self-harming. The rigor was physical too. Solitary can result in physical harm, including self-mutilation, as a maladaptive coping behavior. Maladaptive. I don't know that word. I know it, but I don't know what it means. Maladaptive behavior. Dysfunctional, serves severe psychological functions. It refers to actions or responses that hinder an individual's ability to adapt to new challenging situations. Okay. Allen lost 40 pounds, was unable to care for himself, was tased, his face was black and blue, at times it was bleeding, he was poisoned by fecal matter and toilet water. Indifference to his catatonia is shown where medical staff discusses blood pressure and cholesterol. I thought that was so weird, with a vacant Allen. This psychological and physical pain was unnecessary. IDOC could have transferred him upon his deterioration as policy requires. Even an isolated infirmary cell would have been better than the whole designed for punishment. Likewise, the court could have moved him when the court learned of his dire condition. I just don't understand why they didn't. Over 150 years ago, Dostoevsky wrote, "The degree of civilization in society can be judged by entering its prisons." In 2015, writing about the effects of solitary, Justice Kennedy hearkened this quote, "There is truth to this in our own time." He hearkened to this quote, noting, "There is truth to this in our own time," so he was referring back. Applying the exclusionary rule to these constitutional violations would deter abuses within our prison systems and law enforcement, protect judicial system integrity by showing it condemns such conduct, and protect the human dignity of those unable to make bond while awaiting trial. Indiana has a robust exclusionary rule. Indiana adopted this rule long before the Fourth Amendment rule applied to the states. Under the exclusionary rule, to determine whether a statement is the product of an illegal detention, the court must ask if the statement has been come at by exploitation of that illegality, or instead by means sufficiently distinguishable to be purged of the primary taint. I don't like that sentence. Taint. the evidence obtained by taking advantage of the original illegal action, or was it gathered in a way that's separate enough that the earlier illegality no longer matters? Did the police get this because of an illegal act, or did they later get it independently and cleanly enough that the original wrongdoing doesn't contaminate it anymore? The court considers the time elapsed between the illegality and the acquisition of the evidence, the presence of intervening circumstances, the purpose and flagrancy of the official misconduct. First, Allen's statements occurred during the illegality of his detention at the WCU. Second, there were no intervening circumstances. Again, there was a well-known connection between solitary confinement and psychosis and delirium. Third, the constitutional violation was flagrant because IDOC violated its own policies for keeping Allen safe, and the court and the prosecutor refused to help when Allen's attorney warned of his deterioration. Even if this court finds Allen's statements were voluntary because he was not interrogated by law enforcement, he was still gravely disabled when he confessed. As such, his free will did not purge the taint of his illegal detention. The trial court erred by denying the motion to suppress. Before a federal or state constitutional error can be held harmless, the court must find it was harmless beyond a reasonable doubt. How do you find that this is harmless beyond a reasonable doubt? There's no fucking way. There's no way. No piece of evidence may have a greater sway over a jury than the defendant's confession. The erroneous admission of statements to Dr. Walla alone was prejudicial because they were a large part of the state's case. The prosecutor particularly concentrated on Allen's May 3rd statement, arguing that Allen knew a fact only the killer would know. The confessions also countered Allen's confident and unwavering pre-solitary protest of innocence. The Fourth Amendment guarantees a defendant the right to a fair trial. The amendment's due process clause places significant, substantive limits on the state's power, prohibiting its arbitrary exertion and guaranteeing criminal defendants a fair opportunity to defend against the state's accusations. Chambers versus Mississippi. For an opportunity to be fair, a defendant must be permitted to confront and cross-examine witnesses and to call witnesses in his or her own behalf. These overarching principles operate in tandem with the Sixth Amendment, which similarly guarantees criminal defendants a meaningful... One second, my husband's calling. Hold on. Hello? Hello? Stop it right now. 900 times he's calling. What the hell are you doing? You're making me mad. Where are you? Stop. I'm going to voicemail. I will not leave a message, you fucker. What are you doing? Are you hungry now? Clearly he's hungry now. Alright, who's getting deleted? You've been kicked out of here, motherfucker. Hold on, I have to order some food. Chat amongst yourselves. How are y'all, by the way? Once I get to reading, I'm like... So... He's hungry. Clearly. He's a hungry man. Tonight we shall have Japanese food. I don't want any of that. That is not the one I like. Here it is. You're cooking dinner? I'm not cooking dinner. No, I don't want to. I don't want to. View cart, please. Okay. Okay. Just give me 1 second. I want to... I said, are you hungry right now? By the time it gets here, I will be. Okay, crazy. All right. Boy. Chicka-chow. Maybe I'll get my son the same thing as my daughter. I think so. Alrighty. Get rid of those. So those are exactly the same. These are different. Okay. No, I don't want any of those things. Thank you. What the hell is this payment? I don't know what that is. You don't want to cook either? I don't either. I don't want to. I did want to. I just don't feel like it. I usually have deals on here though, and I don't see one. Give me a deal, Hope. Let me see. Your past orders. Alright. Look at my arm, what my dog did, little sucker. Little sucker. Ugh. Alright. Alright, it's going to take about an hour. No. I hate when it tries to trick you to do that stupid subscription. I don't want that. Come on. Alright, so there's that. And we're almost done with this too, so. Alright. Although trial courts have broad discretion in conducting trials, Joyner versus State, this discretion has constitutional limits. That is, courts may not infringe upon a weighty interest of the accused, through decisions that are arbitrary or disproportionate to the purposes they are designed to serve. As explained more fully below, the trial court made several reversible errors under the rules of evidence and Indiana's trial rules. In many instances, these decisions violated the Constitution as well. While this court assesses claims relating to admitting or excluding evidence for abuse of discretion to the extent that those claims implicate constitutional issues, this court reviews them from the beginning. Errors in the admission of evidence will be disregarded as harmless if its probable impact on the jury in light of all the evidence in this case is sufficiently minor so as not to affect the substantial rights of the parties. But when the error is constitutional, the standard is higher. Generally, before a federal constitutional error can be held harmless, the court must be able to declare a belief that it was harmless beyond a reasonable doubt. The court committed reversible error by excluding Blair's sketch of the bridge guy. That decision violated our rules of evidence and denied Allen his constitutional right to present a defense of mistaken identity. True. Evidence is relevant whether it has any tendency to make the existence of any fact that is a consequence to the determination of the action more probable or less probable than it would have been without the evidence. I mean, had they have shown that, how could they say, oh yeah, that looked just like him? You couldn't have done it. A court may exclude relevant evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusion in the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. Blair's sketch provides she did not see Allen on the bridge. Blair did not identify Allen in court as the bridge guy. But according to the prosecutor, Blair must have seen Allen on the bridge because Allen told us he was on the bridge out to the first platform, which is exactly where Blair saw the bridge guy. Blair's sketch shows Allen looks nothing like this person. Just 3 days after the murder, Blair met with a sketch artist and described the man she saw: white, about 20, medium build, brown curly hair. An artist created the following sketch, and it looks nothing like Allen. At the time of the murders, Allen was short, 44 years old, with closely cropped hair. Blair's sketch also shows that she and Sarah saw two different people. The state's timeline for the murders is dependent upon Sarah and Blair seeing the same person. The prosecutor told the jury that every eyewitness is adamant that the person they saw was Bridge Guy. There is no doubt in their minds. But Blair's sketch disproves this. Sarah, like Blair, made a sketch. When Blair saw it, she described it as wrong and not who she saw. Blair's sketch impeaches the investigation and shows law enforcement's bias against Allen. For 2 years, law enforcement circulated Sarah's sketch without it yielding a single arrest. So in April 2019, ISP released Blair's sketch, declared that it represented the face of Bridge Guy, and announced that Blair and Sarah did not see the same person. After Allen's arrest, the story changed, and the story was told Sarah and Blair saw the same person, which is insane. How do you do that? How can you be that? This is why they didn't let us see this fucking trial. This is why we weren't allowed to see this trial. So crooked. Blair's sketch was reliable and probative of Bridge Guy's identity. Blair contacted law enforcement the day the girls went missing, and it was very clear to her she saw Bridge Guy. 2 days later, she developed her sketch with an artist and a book of facial features. She rated her sketch a 10 out of 10 for accuracy. She met with law enforcement repeatedly and reaffirmed her confidence in the sketch. She insisted she could identify Bridge Guy if she saw him. Blair's sketch is not hearsay. Indiana bars the use of out-of-court statements for the truth of the matter asserted, unless the statement falls within an exception. Here, Blair's sketch was not a statement. Although Indiana has not reached the issue, other courts hold that a sketch is the functional equivalent of a photograph. No statement is involved. The sketch is not hearsay. A statement is not hearsay if the declarant testifies and is subject to cross-examination about a prior statement, and the statement is an identification of a person shortly after perceiving the person. The rule applies regardless of whether the identifying witness makes a positive in-court identification or not. Here, Blair identified Bridge Guy to law enforcement immediately, developed her sketch 3 days later. Blair's sketch is also admissible as an adoptive admission. A statement is not hearsay when it is offered against an opposing party and is one of the party manifested that it adopted or believed to be true. That occurred here. In April of 2019, the ISP released Blair's sketch to the public and declared, "This is the face of the Bridge Guy." Blair's sketch is admissible under Indiana's common law, too. Decades before Indiana adopted the rules of evidence, sketches were admissible if the eyewitness took the stand at the trial. Even if the sketch was inadmissible hearsay, Allen was still entitled to use it. The state law does not have the last word on hearsay, and the rule must yield to the constitutional right to present a defense. Hearsay is admissible when other law requires it. When identity is crucial to a case, a defendant is entitled to defend on a claim of mistaken identity. And this right cannot be abridged through the application of arbitrary or disproportionate rules or the mechanistics. I don't like that word either. Well, let's see. Rigid. Okay. Abridged through the application of arbitrary or disproportionate rules, or done in a rigid application of otherwise rational rules. Excluding the sketch violated the Constitution. Here, the state concedes the Bridge Guy's identity was crucial to the case. If we can determine who Bridge Guy is, we can determine who killed Abby and Libby. Blair's sketch was critical to Allen's defense of mistaken identity, and the judge's decision to exclude it was arbitrary and disproportionate to any legitimate government interests. The error was harmful under both constitutional harmless error and Indiana's evidentiary standard. There is no dispute that the state's timeline depended upon Blair seeing Allen on the bridge, and Blair and Sarah seeing the same person. Blair's sketch disproved both points. Excluding it affected Allen's substantial rights in the jury's verdict. C. The court committed reversible error in excluding Tobin's testimony. Allen tendered William Tobin to explain the scientific community's robust criticism of the AFTE's tool mark matching methodology. The judge excluded him because he was not a firearms expert. He was untrained in firearms identification. He did not examine the evidence in the case. He did not conduct a firearms examination. According to the court, Tobin's testimony does not go to an issue before the jury and lacks relevance. This decision violated our rules of evidence and violated Allen's constitutional right to a defense. Expert testimony should be admitted if 1. The expert is qualified by knowledge, skill, experience, training, and education. 2. The testimony will help the trier of fact to understand the evidence to determine a fact and issue. And Indiana adopted this rule to liberalize the admission of expert opinion. Tobin was clearly qualified to explain the scientific community's robust criticism of AFTE methodology. He is nationally recognized as an expert in forensic metallurgy, I hate that word so much, and material science, who has testified as an expert in many cases involving the validity and reliability of firearms and tool marks. He has extensive experience in that word right there, bullet and lead analysis, and tool mark principles, along with a background in statistics. He understands the President's Council of Advisors on Science and Technology, which has issued a detailed report criticizing the AFTE methodology. Tobin's testimony was essential for assessing Oberg's credibility and determining what to believe. Once an expert takes the stand, their credibility is fair game for impeachment, and a party is free to challenge the expert's methodology with opposing testimony from another qualified expert. The jury is ultimately responsible for assessing the witness's credibility and determining what to believe. Here, Oberg testified that she matched tool marks on test firings from Allen's gun with tool marks on the unspent cartridge found at the murder scene, which is crazy. Oberg told the jury she found agreement between the tool marks by using AFTE methodology. She gave an error rate of 2.2% for false positives and 2.87 for false negatives. She discussed studies and articles that she reviewed to apply the methodology. And over relevancy objections, she described studies relating to guns that were not even a Sig Sauer Model P239. A lay juror might find this testimony impressive and coherent, but AFT's methodology is anything but straightforward. Tobin's experience would help a jury understand the scientific community's criticism of this subjective methodology and force Oberg to engage with that critique. Even if our rules tolerated Tobin's exclusion, the decision was patently unconstitutional. A defendant is entitled to a meaningful opportunity to present a complete defense. This entitles him to impeach a witness who provides a crucial link in the proof of the defendant's guilt. Although the trial courts possess broad discretion to limit impeachment, the discretion cannot be used to arbitrarily exclude competent, reliable evidence bearing on witness credibility when such evidence is central to the defendant's claim of innocence. In this case, Oberg's credibility was central, and the judge arbitrarily excluded Tobin. He is an expert in the methodology and its shortcomings. He has experience with firearms identification, and he examined Oberg's materials. There was no legitimate state interest in excluding him. Allen did not waive his right to appeal the Tobin issue by calling Warren. A party aggrieved by an erroneous evidentiary ruling is entitled to respond to the improper ruling without sacrificing the right to appellate recourse. Once the court excluded Tobin, Allen responded by calling Warren, who endorsed the use of AFTE methodology and engaged Oberg in a battle of experts over how to properly apply the methodology to the evidence. This decision did not waive Allen's right to appeal Tobin's exclusion. The error was harmful under both the constitutional standard and the evidentiary standard. The state told the jury Oberg's never been wrong, and that Allen has no explanation of how his bullet from his gun ended up between the bodies of Abby and Libby, 6 inches from Libby's foot. Had the jury heard Tobin's robust impeachment of Oberg's methodology, the outcome of this case would probably be different. The court committed reversible error in admitting hearsay to rehabilitate the timeline. Uh, the state built its entire case upon the following. Allen encountered the girls at 2:13. He completed the murders alone. Left Libby's phone at the murder scene. Was spotted by Sarah leaving the scene at 3:56 and never returned. If Allen committed the murders, there should be no human-initiated activity on Libby's phone after 3:56 p.m., but there was. At the trial, Allen called Eldridge, a former FBI forensics examiner who examined the data from Libby's phone and testified that wired headphones or an aux cable were plugged into the phone at 5:45 p.m. on the 13th and removed at 10:32 p.m. This action would silence a phone call. And she noted that the data showed an incoming call moments before the headphones were inserted, suggesting someone was intentionally silencing Libby's phone. Since the state claimed Allen left the murder scene at 3:56, Eldridge's evidence eviscerated the state's timeline and showed someone else committed the murders. The state responded by asking Cecil, its phone expert, whether water damage could simulate headphones being plugged into Libby's phone. Over a hearsay objection, Cecil testified he Googled it and found some unspecified, non-peer-reviewed troubleshooting forums that reported it could. Cecil's testimony was inadmissible totem pole hearsay. Unless our evidence rules provide otherwise, out-of-court statements are not admissible for truth. What? Hold on. Hold on. Why are you calling me fool? No. Hold on. I need to know if he just called me on my phone to say, can you come feed the dogs downstairs? Where do you think he is? He's downstairs. Does that make sense to any of you? Why somebody would call your name 5 times instead of calling your phone to ask if you can come downstairs to feed the dogs that they are sitting beside. I just want to know. I just need to know. That's all. That's all. Yeah, total sense. He's a man. He can lick my... Listen, Linda. Okay. We're almost done. Alright. So we know that he testified all of this, blah, blah, blah. The rule, however, does not authorize experts to parrot facts that the expert adds nothing to, you would think. Cecil added nothing. He was a mouthpiece for totem pole hearsay that he Googled. The error was constitutional. A defendant is entitled to a fair opportunity to defend against the state's accusations. This includes the right to impeach a witness through cross-examination when they provide a crucial link in the defendant's guilt. Here, the judge arbitrarily allowed the state to undermine Eldridge's testimony with a person's internet post. It was impossible for Allen to impeach the person through cross-examination, and the error was harmful. Eldridge's testimony undermined the timeline upon which the state built the entire case. Allowing the state to rehabilitate the timeline affected Allen's substantial rights and the jury's decisions. The court committed a reversible error by excluding evidence that impeached the credibility of Allen's confessions. Okay? At trial, Allen sought to impeach the credibility of his confessions. The judge made 3 reversible errors. 1. The court erred by excluding the audio from Allen's solitary confinement videos, which is also crazy. At trial, Allen moved to introduce 15 videos showing the conditions he endured in solitary confinement. The court sustained the state's hearsay objection and ordered Allen to mute the videos when he showed them to the jury. This was a reversible error. The audio shows a delusional, confused, disorganized mind. The evidence can only be fully appreciated by listening to it. Accordingly, Allen respectfully requests this court to watch the videos with audio. The statements in those videos are not hearsay. Statements are not hearsay when used to prove a defendant's state of mind. This was precisely Allen's purpose in offering the evidence. To the extent there are older cases suggesting that a defendant can never admit his own statements, those decisions are inconsistent with and should not survive the adoption of the modern rules of evidence. The audio in the video is also relevant because it impeaches Dr. Wallace's testimony and undermines her medical records. Wallace's evidence gave the misleading impression that Allen provided organized and detailed confessions with a beginning, a middle, and an end. But the omitted audio rebuts this, showing a disorganized, nonsensical, confused Allen. For example, Wallace describes Allen's mind as more organized than he had been, but the April 28th video puts this statement in context, showing a disjointed, tangential, nonsensical, rambling Allen. He is plainly psychotic and uncredible. The audio also presents a vivid picture of solitary confinement. I'm going to lose my mind. Hold on my phone again. He said it's sad. Chi-Chi keeps walking to the kitchen looking for food. I can't with him right now. All right. The audio presents a picture of the harsh conditions. Staff speaks horribly to him. Guards remark how long feces is on his back. Inmates tell him to kill himself, and the medical staff ignore obvious signs of SMI and over-medication. In one video, medical personnel ask Allen about his cholesterol and blood pressure. Without the audio, the video presents a misleading impression that the medical professionals are attentive, when in fact, they're not. The trial court commits reversible error in prohibiting the jury from hearing 2 phone calls Allen made on April 3rd. On the 2nd, he called his mother and discussed finding religion. In the early morning of the 3rd, he made 3 intertwined calls. Over objection, the jury heard the 2nd call where he confessed to his wife. But the jury was prohibited from hearing the calls that bookended it, where he questioned his own sanity and the veracity of his own statements. Trooper Harshman's testimony made it worse. Over objection, Harshman claimed that when confessing, Allen was calm, subdued, and solemn, showing no indication of duress or stress. But the excluded April 3rd call discredits this. He was confused and forgetful. He believed he was losing his mind, and he referred to himself as being mentally tortured. He had told that they played this because he told that he had found Jesus the day before. The excluded April 3rd call tells a different story. He said he was losing his mind, showing lapses in memory, confusing dreams with reality, and the prosecutor got to offer an inculpatory story for how the confession started, when Allen was prohibited from presenting exculpatory story through contemporaneous evidence. All right, at trial, Dr. Gracian, we're going to call him Grayson, testified Allen suffered from delirium, but the judge prohibited that from being discussed. This was reversible. Allen's statements were not hearsay. He offered the statement to show his state of mind and prove that what he was saying was unworthy of belief. Second, even if hearsay, the statements were admissible under Evidence Rule 703, which provides experts may testify to opinions based on inadmissible evidence, provided that it is of the type reasonably relied upon by experts. Okay? Harshman testified that Allen's confessions were consistent with the facts and included details only the killer would know. The state also paraded witnesses before the jury who opined Allen's mind was intact when he confessed and that he was faking his symptoms. Dr. Walla testified she saw no reason to screen Allen for delirium. Allen was entitled to counter all of this with evidence that his statements were false, inconsistent with the murder scene, and consistent with delirium. Independently, this error was harmful and warrants reversal. In closing, the prosecutor molded a story that, despite Allen's undisputed psychosis, his confessions were truthful. The judge affected the jury's decision when she prohibited Allen from showing that he made repeated untruthful confessions. Together, the above three errors violated the Constitution. The Constitution prohibits a court from stripping a defendant of the power to describe to the jury the circumstances that promoted the confession, and that is precisely what occurred here. All right, Allen filed a timely motion to correct the errors and argued the state elicited false testimony, and they allowed it to go uncorrected. The trial court denied the motion. What is wrong with these people? The 14th Amendment is violated when the prosecution knowingly solicits false testimony or knowingly allows it to go uncorrected. According to Dr. Walla, Allen confessed that he was attempting to rape the girls but abandoned the effort and fled with them across the creek when he saw the van. At trial, the state elicited testimony from Brad Weber, who told the jury he left work at the Subaru factory in Lafayette, Indiana at 2:02 and drove his white cargo van directly home. The prosecutor told the jury that the timeline for Weber's testimony, Allen's confession, and the step data on LG's phone match perfectly. Yeah, if you take a look at the health data app, there's a pause in the movement for 7 minutes. He has 7 minutes with them. But before he can finish the deed or his deeds, he sees a van, Brad Weber coming home from work, his private drive to his home, and he scares Allen. When Allen forces the girls across the creek to a spot in the woods, a secluded spot, he kills them and cuts their neck. Weber's testimony was false, and the state knew it. Specifically, security cam footage from Weber's neighbor show him arriving at 2:44. An FBI report shows Weber's cell phone arriving home at 2:50. The error was constitutional and requires a reversal. Here, false evidence, if corrected, would show that Weber's arrival home was inconsistent with the state's murder timeline. He arrived home 25 minutes after the pause in movement on LG's phone, and nearly 15 minutes after LG's phone was on the side of the creek, hundreds of yards away from Weber's home. It's impossible. Thus, Allen's statements to Waller are inconsistent with the truth and suggest he was delirious. All right. They prohibited him from explaining the murder scene as a ritual killing, which I think they should have really been able to drive this home, but I guess not. Evidence which tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime. Here, Allen tendered Dawn Perlmutter, a recognized expert in ritualistic killings and atypical homicides, to explain the elements of a ritual killing, usually outdoors in a wooded area near bodies of water, usually on holidays significant to the group, and involve the use of ceremonial knives. There will be symbolism at the scene. With Norse pagan rituals, the symbolism will likely involve runes, arranging natural objects in a specific way, and perhaps combining the runes with blood, blooding the runes. You don't get bullet wounds with ritual murders. Rather, there is usually throat slitting, blood loss, torture. You would expect the sacrifice to be displayed or arranged at the scene in a manner that's significant. And finally, you would expect to see atypical or symbolic blood patterns. According to her, this murder scene included all of those elements. The murders occurred outdoors in a clearing near a creek. The murders coincided with the Nordic holiday Valisblot, which honors Odin's son, Vali. The girls' throats were cut with a knife and they bled extensively. Perlmutter found the sticks to be obvious symbolism and difficult to explain in any other way. In her opinion, the stick arrangement on Abby mirrored the Norse rune Gabo. Gabo, I'm not sure how to pronounce it. And the stick formation on Libby looked like a Nordic bind rune, which it did. Perlmutter also explained that the bodies were arranged in a manner consistent with a pagan ritual. Upside down hanging of a body is an important element in Norse paganism because Odin hung from a tree for 9 days before discovering runes, and Odin's leg is often displayed with one leg bent behind the other. The patterns on the girls' faces we talked about, it appeared their torsos and necks went above their chin. Her leg was bent under the other, mirroring the classic image of Odin. The blood pattern on the tree looked like the Norse pagan Feyu rune. She had knowledge, skill, and experience to offer this testimony. Expert testimony should be admitted if they are qualified, etc., and she is qualified. She's the author of Ritualistic Crime Scene Investigation, a field guide for law enforcement. She teaches about the ideological and ritualistic killings. She is familiar with the Norse paganism and Odinism, and she was qualified. Her testimony was not conjecture. There was always a discussion among law enforcement that this could be a ritual murder. The BAU declined to exclude pagan ritual as a plausible explanation. A consulting professor found it quite plausible, and the stick markings constitute an instruction inspired by Norse runes. An undercover law enforcement officer familiar with runes also found pagan symbolism at the scene. It would have been helpful. Although motive is not an element of murder, juries want an explanation for the crime. And when the motive is unclear or inconsistent with the defendant's guilt, juries are more likely to acquit. Similarly, when a murder is seen as complex or unusual, it's important the jury receive an explanation. Here, it was complex, unusual, and the jury would naturally want an explanation. The sticks immediately stand out to any rational person as unusual and warranting an explanation. She would have provided testimony, all of that. Excluding her violates the Constitution. A defendant is entitled to answer the prosecutor's case with their version of the facts, so the jury may decide where the truth lies. And a judge cannot infringe upon these rights through arbitrary, disproportionate, or mechanistic application of the rules. But she did, because she sucks. So, they want that reversed too, and that's a major error that they made. And he wasn't allowed to do any third-party evidence, nothing. So, we already went over all the third-party stuff. Here we go. The day the girls went missing, law enforcement learned that Abby was having a secret relationship with Logan Holder, the son of Brad Holder. That week, law enforcement interviewed Holder and his friend Patrick. Holder reported being involved in a pagan tribe, spent every weekend in Delphi, engaging in pagan rituals with Westfald and 5 or 6 others, including women. These rituals involved animal sacrifice and human bloodletting. Holder told police he owned a .40 caliber gun, but police did not examine it or collect the weapon, nor did they search his phone. Holder told police he was at work at Liberty Landfill when the girls went missing. Law enforcement recorded over his interview, permanently deleting it. In his interview, Westfall told law enforcement he knew the woods where the girls were murdered very well. He reported knowing the girls, but denied ever meeting them. He was a religious leader for local pagans and wore a necklace to the interview representing his efforts to pledge the Vinlanders. Law enforcement neglected to record his interview. When asked for an alibi, he claimed he was at home with his son. In the 5.5 years between Westfall's interview and Allen's arrest, law enforcement took no further action. He was reported constantly, older, but they spoke with Susan Case. We read all of that. We read all of this. Fight with Westfall. Conclusion. The very premise of our adversary system of criminal justice is that it is partisan advocacy on both sides of a case that will best promote the ultimate objective, that the guilty be convicted and the innocent go free. Because the trial court prohibited the jury from hearing Allen's side of the story, showing how law enforcement went down the wrong path, justice could not be done. The appellant, Richard Allen, requests this court reverse his conviction. These are his lawyers now. Stacy Ulana. Let's look them up really quickly. I liked his other attorneys too, though. Stacy and Mark are judges on the Massachusetts Appeal Court. Stacy is an Associate Justice, Massachusetts Appeal Court, former prosecutor, and Superior Court judge before elevation to the Appeals Court. Mark is an Associate Justice, Mass Appeals Court, former Superior Court, with a background that includes prosecution and private practice. When you see them listed together, it means they were members of the panel deciding an appeals court case. They are the lawyers for Richard Allen's appeal now. So they identify the legal errors made at the trial level, argue violations of constitutional rights, challenge the rulings that may have tainted the case. Attorneys like these don't retry the facts. They go straight after the specific procedure, legality, and judicial mistakes. Very nice. Very nice. Thank you for becoming a member, JJ. No, I don't think so either. I don't think so either. Ah, what? Wouldn't you think? I would think, but who really knows? Who really knows? Alright, now I must go feed the dog so that Scott doesn't cry anymore and call me, okay? And maybe I'll be live on the porch later to talk some shit. But that's not the place for it right now, okay? Merry Christmas to you too. I'll probably be on, if not later tonight, then at some point tomorrow. Alright, off I go.